Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis, happy Friday. Hope you guys have had a really good day. I said I was going to take the day off for family, and I did mostly. Just got back from my aunt and uncle's house. And but then this happened. So here I am. I can't stay away when stuff like this hits the news. So first off, thank you to Maria for the donation. I really appreciate that. Also, song fact of the day. The song Drive by the Cars is definitely in my top 5 of 80 songs. I have top 5s for every decade, y'all. I'm a music nut. But it's a beautiful song, but a lot of people don't really know what the lyrics mean, but it's essentially written for someone who's in self-denial. And a lot of the interpretation has been about somebody who's struggling with addiction that constantly pushes people away who's trying to help. And it kind of fits if you think about the lyrics, who's going to pay attention to your dreams? You can't go on thinking nothing's wrong. And so the singer's trying to get this person to engage in some self-reflection because they see they're on a very destructive path into their future. So really good song. I'm going to listen to it later when I'm doing some things around the house. And before we get into the ruling by Judge Boyce, I want to thank you guys for the sweet, sweet messages about my uncle's funeral today. It was a mixture of belly laughs and lots of tears, and it was very fitting for him. And he literally spoke at his own funeral and had us all laughing. So one funny story that I have to tell you guys, because my family is everything to me, and I've been raised collectively by this. We call ourselves a tribe. And my grandmother was quarter or half Cherokee. And so just we're a unit. But my uncle there was a group of 3, and they were friends, and they were known for practical jokes. I mean, sometimes they would literally put a clunker car on somebody's lawn at 2 a.m. Well, one of them passed away a few years ago, and he was known to never be without a cell phone. So they decided they were going to bury him with a cell phone. Well, right before they closed the casket, my uncle grabs the cell phone and kept it. And about 2 months later, randomly, his other friend is eating breakfast, and my uncle picks up the phone and calls his number. And his wife said his face went totally white. So the joke was that when my uncle got to heaven last week, his friend who was already there was standing there with a sign that said, "Welcome to hell." So just a fun guy. Gosh, I'm going to miss him so, so much. Lots of amazing memories as a kid and adult with him. And we definitely paid tribute to him today. So thank you guys. All right. So we're going to get down to business here. First off, as you know, Judge Boyce has banned cameras, not only for pretrial hearings, but the entire trial. I'm just going to take a moment and breathe. All right. So Kay and Larry Woodcock sent a statement to Nate Eaton from East Idaho News, one of the OGs of the case, him and Justin Lum, 2 of my very favorite journalists ever now. And they said, "We are disappointed and distraught in regards to Judge Boyce's decision to not allow court cameras. Although we want justice for JJ, Tylee, Charles, and Tammy, we feel he overreacted. The simple solution is not to televise preliminary hearings in order to not taint a jury pool, yet still allow cameras during the trial. Some of our immediate family, close friends, and supporters from across the globe will not be able to share in this most horrific story. The story speaks from beyond the graves. We want the world to hear the atrocities executed by Lori and Chad Daybell." 100% hit the nail on the head with that. It's not fair. Number one, you've got people in Madison and Fremont counties that are fronting the money for this trial. Not everybody can drive 3+ hours to attend, pay to get a hotel, pay for their meals. And he says he's going to reserve some seats in the courtroom for people that come from that area. But here's the thing. It's all about pretrial publicity. And we're going to get into what he actually says. But here's the thing. I've said this a million times. The toothpaste is out of the tube. This case has been publicized since the kids went missing back in December of 2019 when it hit the news. We know they were missing long before then. They were murdered in September. Lori and Chad caused the pretrial publicity because of what they did. Now, I totally get that networks jump on this and you get documentaries. We've had a Lifetime movie. We've had countless documentaries about this case already, but it's 2022. That happens with everything. I don't understand this. I hope the media fights this tooth and nail. There's time. So we're going to read through this and we're just going to skip and go to the background. It says a protection of the penal system in the United States of America is the insistence of a fair trial by an impartial jury to those accused of even the most severe crimes as set forth in the Sixth Amendment of the United States Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have the process for obtaining witnesses in his favor, and have the assistance of counsel for his defense. And so it says the court is presented today with a joint request from the defendant and the state to disallow certain media activity in future courtroom proceedings in this case. Countering that request are several media entities who have argued that the First Amendment affords the media certain rights and that those rights are best achieved by audio and video coverage of court proceedings. To be clear, no party has argued the court should fully prescribe media coverage of this case by issuing a prior restraint on speech, such as a gag order on media reporting. Rather, the request of the defendant and the state in its concurrence is that the court clarify or reconsider the scope of the media's activity authorized by the court's order governing courtroom conduct issued in the case April 14th of 2022. The instant case has garnered significant media attention worldwide. Fails to mention because, well, look at what they're accused of doing. Like, this is going to be local news, really. The court has previously considered it's a Shepard versus Maxwell case upon determining that Idaho Criminal Rule 21A applied. The court ordered a transfer of trial from Fremont County, Idaho, to the most populous county in the state, Ada County, in order to mitigate the effects of pretrial publicity and its detrimental impact on selecting an impartial jury. See, the thing is this: jurors take an oath. And if they're honest when they're being questioned about becoming a juror, then you have to trust jurors these days. We have like every piece of news right here in our hands. You have to trust juries are not going to look stuff up. They have got content for months or years at their fingertips right now. And if you think most people in Ada County don't know the details of this case, you're on another planet. Sorry, I'm on a tangent. I'm tired and it's just going to come out, y'all. So it says the presiding judge maintains the right to limit audio and visual coverage of any public hearing when the interest of the administration of justice requires. Authorization may be revoked at any time without prior notice when, in the discretion of the court, it appears that audio and visual coverage is interfering in any way with the proper administration of justice. The presiding judge may, at his or her discretion, limit, restrict, or prohibit audio-visual coverage at any proceeding. Any decision regarding audio-visual coverage is not subject to appellate review. First, the court affirms that there is no indication that any orders relating to the conduct of the media during hearings in this case or the companion case, Fremont County case CR 22-21-1623, State of Idaho versus Chad Guy Daybell, have been violated. The court likewise witnessed no misconduct on any part of the media during hearings in these cases. The presence of media during the hearings has in no way interrupted those proceedings, and attending media have been respectful and professional. Notwithstanding, the court determines that the concerns raised in the defendant's motion to clarify media in the courtroom and the state's concurrence are well-founded. The court has carefully considered the arguments presented at the September 15th hearing on this issue, including the arguments of Mr. Wright, counsel for numerous media clients. Subsequent to the hearing and upon request of counsel, The court also reviewed the video footage of an August 16th hearing as cited in the state's concurrence. The court concurs with defendants' arguments that the footage of the August 16th hearing demonstrates a focus on the defendant zooming onto her face throughout the vast majority of the hearing, regardless of who was speaking or what was happening. This court has previously permitted cameras in the courtroom during this case, allowing both photography and video transmission, which you really kind of contributed to pretrial publicity in allowing it in the first place. So why are we here? But when the case is a sensational one, tensions develop between the right of the accused to trial by an impartial jury and the rights guaranteed others by the First Amendment. The capacity of the jury eventually impaneled to decide this case fairly is influenced by the tone and extent of the publicity. Such is precisely the conflict here. While the right to public access must be protected, the scope of the coverage cannot supersede the rights of all parties to the fair administration of justice in this case. Courts have historically struggled with the issue of permitting cameras in the courtroom. Going back decades, cases have been overturned by the U.S. Supreme Court because of issues relating to its extensive media coverage. In this day and age, the problem is further, that's blurry, where instantaneous access to coverage provided by traditional media outlets is quickly rebroadcast, repackaged, and reimagined. The court has previously been made aware and continues to be informed that documentaries, dramatizations, and fictionalized movies focusing on the defendants and allegations in this case have already been produced and continue to be given to the public. All this continues to occur in a case which has not been tried. That's not the general public's fault. That is the fault of these media companies that choose to put out this stuff. And here's the thing. How do you know that potential jurors did not sit and watch all 3 episodes of this Netflix series that was released last week? I mean, damage done already. It kind of, at that point, it's the trial, it's the facts, it's witnesses, it's stuff they haven't heard. So I don't know. Maybe I'm not a lawyer. Should have went to law school clearly, but it just seems really, look, I don't care about pretrial hearings. I don't care if I see another one. It's nothing major in there. But I do think that it's fair, especially like Kay and Larry say, they've got family members that can't travel to this trial, for 10 weeks or gosh knows however long it's going to go. And I mean, at this point, the cat's out of the bag. The court is very concerned that continual visual coverage of this case will impede the ability of the parties to select fair and unbiased jurors. While the court has refrained from delving into viewing the coverage in this case, the coverage is so extensive. The court has had to proactively avoid viewing it as it is routinely part of local and at times national news. The affidavit submitted by Mr. Wright confirms this in that just one of Mr. Wright's 30-plus clients distributes footage from hearings in this case to dozens of media organizations and millions of viewers. In fully considering this decision, the court notes that the media have raised a compelling issue: public access for the citizens of Fremont and Madison counties. The excessive coverage of this case has already resulted in the court's determination that trial will be held in Ada County, Idaho, as the court has previously concluded that it would be unlikely to obtain an unbiased jury pool within the home county of this case, Fremont County. It is unfortunate that local citizens, including citizens of both Fremont and Madison counties, who bear the cost of this case, should be given local access to this trial, should they wish to attend, now cannot do so without inconvenience. Upon full consideration of the arguments of the state and defense, notably concurring with each other, the court is persuaded that further visual coverage of this case will run afoul of the court's considerations as set forth plainly in ICAR 45. That rule provides this court discretion to make determination. It states in part, audio-visual coverage is authorized subject to the discretion of the presiding judge. And it states in part B, states in part, the presiding judge may at his or her discretion limit, restrict, or prohibit audio-visual coverage at any proceeding. The court determines herein that continued visual coverage of this case poses a great risk to the fair administration of justice in this case, and co-defendant Chad Daybell's companion case, which cases are joined for trial. Therefore, continued visual coverage will no longer be permitted. The court determines that this decision applies to all future pretrial motions and trial, where continued coverage of pretrial motions will likely cause potential jurors to be biased, disqualifying them from service. Coverage during trial raises additional and equally serious concerns. The court will not risk the loss of seated jurors who may intentionally or inadvertently review the very trial proceedings they are sworn to decide, where those jurors must make their decision only upon the evidence presented at trial. Here's my thing. Everybody in this case, with the exception of maybe Zulema, has given interviews to mainstream media. You can't tell me that some of these jurors that will be seated have not seen some, all, or most of the interviews that Melanie Gibb gave, that Melanice gave, David Warwick gave. We've seen the preliminary hearing, even though that's not all the evidence. And you still got these documentaries and all these things being made. I just don't understand how at trial you're going to prejudice the jurors. They're going to sit there and hear the witnesses themselves. If they go home and research it on the internet, you can't tell me jurors don't do that. Come on. But you have to trust the jurors. Disqualifying them from service. Coverage during trial raises additional and equally serious concerns. The court, I'm sorry, I just repeated that. The court will not risk the potential loss of state or defense witnesses who may intentionally or inadvertently become tainted by viewing the trial proceedings before they testify, assuming their exclusion from the proceedings as is regularly ordered for material witnesses. The court further is concerned that at trial, the added and unnecessary pressure witnesses and counsel will be subject to, knowing their every expression, utterance, and appearance will be captured and circulated without their control, is unwarranted and will likely interfere with the fair administration of justice in this case. Okay, so have an electronic camera like in the Wagner case. You know what? Let's put the camera on the judge the whole time. If you don't want witnesses to be seen, put it on, something else. I mean, this really just seems like overkill to me. Therefore, in the discretion of the court, pursuant to ICAR 45 A and B, authorization of all video, photographic coverage in the courtroom, in this case, at all further proceedings, including trial, is revoked. Audio recording of all future proceedings will continue to be permitted, with the court utilizing the in-courtroom microphones operated by court personnel. Any third-party recordings will be subject to future approval, if approved, will be monitored to ensure that microphones are located to ensure that unwarranted conversations between counsel and clients are not recorded. Finally, in order to facilitate the attendance of the trial in Ada County by Fremont County and Madison County, citizens who wish to attend and who have lost the ability to attend in person without great inconvenience, the court intends to provide enhanced access for Fremont and Madison County residents by providing designated seating at trial in a manner to be further determined. So in conclusion, defendant's motion to clarify media in the courtroom together with the state's concurrence and express request to remove cameras from the courtroom is granted. Signed today. It was signed at like 1 o'clock or something like that. So I get on one hand the pretrial hearings. They're not interesting. It is sort of a, what does she look like today? I don't care what she looks like. I'm over Lori Vallow. These people back here are what we're focused on. But here's the thing. If they're going to bend, if we just get audio, okay, that's better than nothing. But when you move a trial 3+ hours away from the very taxpayers that are funding it, you are doing a disservice to them to not provide access of this case. And like I say, you could sit for 24 hours and not even scratch the surface of these specials that have been done on the case. I don't see how it's going to be prejudicial to the jury during the trial. I would be hard pressed to find many people in the whole state of Idaho who don't know at least the foundation of this case. Jurors are put on a panel to sit and listen to the facts and to make a decision based on the facts that they are told. If they don't do that, they've broken their oath. That's not our problem. That's not the media's problem. It's 2022. Everything is out there. Everything. It just blows my mind. Hopefully, I don't know. I don't know what the media can do at this point. Hopefully they do something. Hopefully there is some kind of a compromise. But for now, geez, it looks like I'm gonna have to find me an Airbnb up in Idaho and in Boise for 10 weeks and like put my kids in school up there because I don't want to miss the trial. We're all emotionally invested. And like Kay and Larry said, at the end of the day, you have so many people that are personally invested in this trial, family, extended family, that now will not be able to know the facts as they come out at trial because we're not going to have cameras in the courtroom. Anyway, so yeah, it's got me in a mood, y'all. It's got a lot of people in the mood. I understand the pretrial stuff, don't get me wrong. But you know what? Chad and Lori are accused of doing some really, really evil stuff. We wouldn't know their names if they hadn't have done what they done. And we wouldn't have this coverage if the case was not so insanely crazy with these four people being dead right now because of their mission. So don't blame it on pretrial coverage in the media. Blame it on these people that did the murders and so blatantly without any remorse. Still no remorse from either one of them. It's not the public's fault. It's their fault. You know, if you don't want your face plastered everywhere, don't do stuff like this. Don't take people's lives for selfish reasons. You know, I'm cool with them not showing witnesses if that's what they want. Do like the Wagner trial. Opt into being recorded, but let's have some audio at least. All right, I'm off my soapbox. I'm done. I'm gonna breathe. All right. Hopefully, we've got time. It's only September. This goes to trial in January. Maybe there'll be a compromise. But anyways, we'll keep you updated. Hope you have a good rest of your night.